call the meeting to order for the November 8, 2021 Sarasota County Board of Zoning Appeals. I'm going to do the Pledge of Allegiance, please.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Ms. Ledoux, if we could take roll call, please.
Here.
Present.
Here.
Here.
Here. Here.
Here. At this time, we'll open the meeting to the public. Public hearing is a disclosure. The Sarasota County Charter requires that evidence and testimony presented during the public hearing shall be under oath. Persons presenting evidence and or testimony are required to complete and sign a request to speak card. So at this time, is there anybody present that would like to speak and has not completed a card? Okay, thank you. The first item on the agenda is a variance, a public hearing to consider variance 21-162640ZZ. It's a request by Mark and Lori Bogart for a variance of 4.5 feet, 4.5, from the required 20-foot street yard setback along Cal del Otono south property line to allow the construction of a new pool. The property is zoned RSF2, which is residential single family. It is located at 5546 Avenida del Mar, Sarasota, Florida 34242, with the property ID number 0107030004. Ms. Thompson.
Good evening. For the record, Donna Thompson with Planning and Development Services, and I have signed a speaker's card. As previously indicated, this is a variance request by Mark and Lori Bogart for a reduction in the required 20-foot street yard setback on their south property line. This is for the placement of an in-ground swimming pool. This is the aerial view of the property. As you can see, it is located on the corner of Avenida del Mar and Calle del Otano. This is a view of the property along Calle del Otano. The wall is as indicating their property. This is a view of the area where the proposed pool is to be built behind the privacy wall, which will buffer the pool from the view of the street and the adjacent neighbors. This is what the proposed pool is to look like. This is the site plan showing where the pool would be and how close it would be to the street yard along Calle del Otano, and the survey for the property. The approval criteria is on the screen in front of you. They have not started their process. They are in the process of permitting the pool. It would not be contrary to the public interest. They do have a rather constrained site that is on a corner and has 2 street yards. The special conditions are not the result of any actions that they have taken so far. Literal enforcement of the provisions of the zoning regulations would result in unnecessary and undue hardship, and the variance is the minimum necessary to make any reasonable use of the property. So the recommendation before you is that you consider reduction of the 20-foot street yard setback to allow the construction of an in-ground pool. That completes my presentation. I'd be happy to answer any questions if you have any.
Board, do we have any questions? No. Thank you.
Oh, one other thing, I would indicate that we did receive a couple of letters in support of the application. So, Mr. Bogart, if you'd like to come up and speak.
Hello, my name is Mark Bogart. I'm representing both my wife and I. My formal name is Imans Mark Bogart, but I go by Mark. In any event, I did sign the card. We purchased the home 11 years ago here in Sarasota in Siesta Key. We've been traveling here for family and personal visits for over 38 years of our married life. When we purchased the house, we did not live there initially. We moved into it permanently 5 years ago. The house itself was constructed in 1948. It is a Ralph Twitchell and Paul Rudolph house. It is one of 4 Lamolithic houses on the Key. We are going through what we consider kind of a significant investment to preserve the property and expand the property, and we've always wanted to have a pool. We sought out the approval of our neighbors. We got 6 affidavits from neighbors in reference to supporting the pool initiative. The pool itself, again, is relatively small. It's 10 by 35. We do need 4.5 foot of easement, and that's the purpose of the variance that we're requesting. All of the pool is behind walls, so there is no view of the pool to the street. It is a single-story residence. We will not have a pool cage. It doesn't really fit with the architecture of the home or the area. There are 2 of the other 4 Paul Rudolph homes that do have pools. Unfortunately, we do have the condition by which we do technically have 2 front yards, and so therefore the only place to place the pool is in the front yard, or one of the front yards which faces Calle del Tono. Any questions?
Mr. Piacek, you're thinking? No.
I don't have any questions
Okay.
other than
Okay.
everything
Well-
seems to be in order with.
Yep. Well,
Plenty of-
we'll get to that. So no questions. Thank you.
Thank you very much.
And so, Laura, you're going to opt not to speak then? Okay. Yeah, understood. Very good. So I'm seeing no other speaker cards, so we'll have any reason for Ms. Thompson? Anything else? Okay, we'll close that and open up for discussion, please. Does anybody have comments? Yes.
I think this is probably one of the most complete applications I've seen in 6 years. I mean, it is thorough and complete. So with that, I would make a motion to approve the variance.
Mr. Malatesta? Any other comments? If not, we'll just move this right into vote. Sounds good. You take vote, please.
For the motion.
For the motion. For the motion.
For the motion.
For the motion.
For the motion.
For the motion. Thank you. Good luck to you. Thank you very much. Welcome. The second item on the agenda for this evening is an appeal. Public hearing to consider Appeal 21-159855ZZ. It's a request by Erica and Acom Ginsberg-Klemmt to appeal, and I apologize if I got that name botched, to appeal an interpretation issued by the zoning administrator relating to a use of the property at 851 Elby Farm Road, Sarasota, Florida, with a property ID number 03830100001. The property is zoned OUC RSF1, which is open use conservation residential single family. Ms. Thompson.
Mr. Chair, before I start, I'd like to invite Kelly Fernandez, my attorney, up. She would like to speak to you prior to my presentation.
Good evening, Chair, members of the board. My name is Kelly Fernandez, and I'm an attorney with Person, Cohn & Mooney, and I've been retained by the county to represent Ms. Thompson in today's hearing. Ms. Thompson will have her presentation in just a moment, but I wanted to take an opportunity to provide a real brief introduction first. As you will hear tonight, the property that's the subject of this zoning determination appeal was previously the subject of an unsuccessful zoning request by the Ginsberg-Klemmts. The county's denial of the rezoning was later affirmed on appeal by the circuit court. And this request for a written interpretation followed. 27 requests were initially made and responded to by Ms. Thompson. 24 have been appealed, plus there's also tacitly an appeal to the preamble of Ms. Thompson's written determination. It initially struck me that it might be very difficult to have an orderly and clean presentation involving 24 different requests, and that perhaps you should take them one by one. But after Ms. Thompson and I thoroughly went through everything, it's my belief that the determinations, they're not complicated, they don't need to be made complicated. So, I think you can proceed with what you typically do, hearing from the county and then hearing from the appellants. Many of the appealed requests fall outside of Ms. Thompson's scope of authority. The remainder are individually discussed by Ms. Thompson's presentation. You may find, and they're not strictly interrelated, so you may find that as she's going through the request, if you have questions, you may want to pause her after each determination before she moves on to the next one. It may help assist us move through this more logically and orderly. But I do believe when Ms. Thompson concludes her presentation, you will see that all the determinations that she issued should be upheld. And I may come back and have additional comments to make, but next I would ask Ms. Thompson to come forward and do her presentation.
For the record, Donna Thompson with Planning and Development Services, and I have signed a speaker's card. As previously indicated, this is a request pursuant to Article 5, Section 12447 of the Unified Development Code, issued or submitted by Erica and Akeem Ginsberg-Klemmt, appealing a written interpretation which was issued by myself on August 11th, relating to their property at 851 Albee Farm Road in Nokomis. The appeal criteria was included in your packet. They feel they're an aggrieved party to my interpretation. So this is the procedure that's followed. They have 30 days after the issuance of an interpretation to appeal. There are only certain chapters of the UDC that can be appealed, Article 6, 7, 8, 10, 11, 15, or 17. And the action that you need to consider today is to make a determination as to either affirm, modify, or reverse the action of my interpretation. So again, the interpretation was requested by the Ginsberg-Klemmt. It contains several questions relating to their property at 851 Albee Farm Road, as well as several questions relating to other properties throughout the county. The property is located at 851 Albee Farm Road and contains split zoning, RSF1 and OUC, which is residential single-family 2.5 units per acre and open use conservation. The RSF portion is substantially wetlands, while the OUC portion contains an upland area comprised of a spoil island. In June of 2019, as Ms. Fernandez indicated, a rezone application was filed to swap the zoning classifications on the property. So essentially, the RSF would go to OUC and the OUC to RSF in order to construct a home on the spoil island. The rezone was denied by the county commission. Yes.
Is that a common procedure, just swapping zonings?
In this instance, it was a suggestion by our environmental staff because the code does not allow permanent construction in OUC when you have split zoning like this.
Okay, thank you.
The Ginsberg-Klemmt did appeal the rezone denial to the circuit court, but the county's denial was upheld by the court on June 9th of 2021, and in August of 2021, this written interpretation was sought. This is an aerial of the property from our GIS. As you can see, the RSF is denoted by yellow, and the OUC is a mint color. So as outlined in Article 5, Section 12445 the UDC, the zoning administrator is authorized to issue written interpretations, including but not limited to interpretations of the text of the UDC, interpretations of district boundaries, interpretations of special exception stipulations or rezone stipulations, interpretations as to whether an unspecified use falls within a use classification or a use group allowed in the district, and interpretations as to whether a proposed use is of equal or lesser conformity. Interpretation letters shall be rescinded by the administrator if it's determined that they were clearly erroneous and will be superseded by a subsequent changes to the UDC that are in conflict with the written interpretation. They may also be rescinded if there's any changes in the facts that would render the interpretation invalid. And a written interpretation is specific to the applicant and to a particular property, such as an interpretation as to its permissible uses, and does not constitute a determination as to the effect of other county, state, or federal regulations. Stated before, an aggrieved party may file an administrative appeal to the Board of Zoning Appeals on an interpretation on these chapters of the UDC. So the interpretation requested by the Ginsberg-Klemmt contained 27 separate zoning determination requests. Of those 27 requests, 19, numbers 9 through 27, related to other properties within Sarasota County. These requests were not substantially answered as they were not specific to the applicant's site and the use for which the Ginsberg-Klemmt requested the interpretation. Furthermore, these requests question why existing structures were allowed to be constructed, which is outside of my authority. The preamble appeal, the Ginsberg-Klemmt alleged introductory statements made in the written interpretation are discriminatory. Discrimination and equal protection claims exceed the review authority of the BZA to the extent a preamble cannot even be appealed. Request number 2 asks if the county allowed the construction of supporting guy wires on the Albee Farm Road by FPL. The response that was provided was that the electricity is considered an essential service allowed in any zoning district in the county. However, whether private property can be used is an issue discussed between the property owner and the utility company. Request number 3 asks if they would be barred from constructing an access trail driveway to their property relying on section 124.75B, which provides that roads and bicycle and pedestrian and similar trails and ancillary facilities are allowed in any zoning district. This section of the code is titled Essential Roads or Essential Services, Roads and Trails. The roads and trails portion was added when the County Commission amended the UDC with Amendment Number 3, which addressed places of public gathering. Subsection B was added to address the Legacy Trail passing through various zoning districts. As the section is titled, it applies to essential services throughout the county, not driveways to access individual private properties. Request number 6 asks whether construction of an access driveway with an associated WNCA permit application would be allowed as part of a natural areas park in the OUC section of the parcel. A WNCA permit does not fall within the scope of authority for myself. As for the natural area park question, the applicant has not provided any information on how they are developing the parcel as a natural area park, other than it would be in accordance with NAICS 71219. These NAICS codes, which is the National Association of Industry Classification, are not development standards, but merely codes used to find similarities when determining whether a use that is not specifically listed is similar to those listed in the UDC. In addition, a natural area park on the parcel could not exceed approximately 828 square feet of total developed area, as the code limits development to 1% of the property. Request 7 asks whether or not the parcel complies as a nonconforming lot of record in accordance with section 124-283A, which states as follows. A nonconforming lot of record is a lot that was lawfully created but does not meet the current regulations for the district and is one part of a subdivision recorded in the office of the clerk of court of Sarasota County or described by meets and bounds. The description of the lot recorded shall have been recorded on or before November 11, 1975. The lot in question is not part of a subdivision, however, it is described by meets and bounds. It has been determined that it is a lot of record, however, only the OUC portion is non-conforming as it does not meet the minimum lot area of 25 acres. The RSF 1 portion meets the minimum lot dimensions. Section 124-18 of the UDC, except where explicitly provided to the contrary, whenever requirements of this UDC are in conflict with the requirements of any other lawfully adopted rules, regulations, or ordinances, the requirement that is most restrictive or imposes higher standards as determined by the administrator shall govern. Based on this, 124-76A1F3 would govern as it does not allow for construction of permanent structures on that portion of a lot or parcel zoned OUC. The RSF portion may be developed in accordance with the development standards for RSF 1. Request number 8 asks whether the parcel meets the current regulations for the RSF1 zoning district, particularly the environmental regulations imposed by the comprehensive plan, and whether the parcel meets all other criteria for a nonconforming lot. The zoning administrator does not have the authority to provide interpretations of the comprehensive plan, and the nonconforming portion of the request was addressed in request number 7. So, the recommendation before you tonight is that you review the appeal and interpretation documentation, and based on the evidence and testimony provided, either affirm, modify, or reverse the action of the zoning administrator's interpretation. And I'd be happy to answer any questions.
Mr. Mass?
May I ask again, the portion that is RSF 1 is conforming, it is large enough to build a home on it, correct?
Correct.
Any additional questions? No.
It just seems to me that in some of the applicant's material, we have documents or items going back to 2006. So it seems like this has been going on for a while. There's been a lot of back and forth with the county over quite a number of years, and there was a decision, I think, by the Board of County Commissioners, and then a subsequent appeal to in court. Has that been covered at all? I don't know. So anyway, there's a long history here, and you know, so it's been a kind of a long, ongoing situation, and I think staff's presentation, your presentation, it's kind of slimmed down. It's kind of summarized. I mean, because there's a big bulk of things, but I just wanted to basically say that there's a lot of material back and forth here with various county staff and what have you, of different kinds and stripes and different topics and all kinds of things. So.
Correct.
Just wanted to make that
You have to
point.
remember that they are appealing the letter that I wrote this year.
Yes. Okay. Which has, okay. Yes, I'm aware of that. Thank you.
Anything else?
Anything else from Ms. Thompson? Thank you.
I think, as I recall in high school, they told me I'm supposed to pretend everybody's in their underwear. That'll help me relax. I don't know if that's really actually going to help me much. Wrong mouse.
You could just, before you get started, if you could just state your name for the record, please.
Oh, it's all ready.
Okay, thanks.
Just let me, I need a few minutes, guys. And I get to say guys because it looks like we're mostly guys today. Let me just reduce this. Cancel. So I'm going to be reading from one computer and showing my PowerPoint on the other. So here we go. Let's get this show on the road. We have here, oh, it'd be helpful if I put in the USB stick, wouldn't it? Don't start my timer yet. Thank you. B. BZA. Let's do it. Slideshow from beginning. For the record, let's go. I'm Erica Ginsberg-Klemmt, co-owner of the parcel in question. Wife of co-owner, Mr. Achim Ginsberg-Klemmt. This evening, you don't see an attorney up here with me. You don't see an agent. You don't see any expert witnesses. Sadly for us, no amount of logic and science, no amount of adherence to the comprehensive plan or best practices, even no amount of equal testimony for the logical solution to this problem has outweighed the political pressure that the neighbors have impressed upon other neighbors and deciding bodies at the county. I therefore stand before you blue-haired and alone as the appellant from a zoning code interpretation letter submitted by the zoning administrator on August 11th, 2021. Prepared to answer any of your questions, we have our agent and renowned Sarasota environmentalist, John O'Miller and Mr. John Cole. They're both in the audience. John Cole is the owner and principal engineer of Giffel Webster's Engineering with us today. He helped us prepare an environmental resource permit for the FDUP and the federal U.S. Army Corps of Engineers permit, which we received for the driveway and culvert construction. We are appealing the zoning administrator's interpretation of the Sarasota County UDC. In the next 20 minutes, actually 18 minutes and 42 seconds, we'll be pointing out specifically the misinterpretations that she made. And we request to confirm the following land use rights on split zone parcels, OUC RSF lots. Zoning request number 3, we'll start small and get bigger. The right to a private road, trail, and to ancillary facilities in the OUC zone, that is according to 12475. The request number 6, the right to establish a natural areas park in the OUC zone. We also request the BZA to acknowledge that the zoning administrator's conclusions to zoning request number 6 are factually incorrect because the proposed driveway is entirely located inside OUC zone, and to acknowledge that 1% of the parcel size is not equal to 828 square feet. The reason we added that caveat in there is because I believe somewhere there's a condition saying that if we don't say that and we don't go against it, it could be written in stone. So we are going officially against those determinations. Zoning request number 7, the right to build one single-family detached dwelling on a non-conforming lot of record in the OUC zone. Let's move on. Let's see if that works. Oh, it does. So this slide shows some overlays which expose the crux of the problem on our 10-acre parcel outlined in red. Everything you see in orange and yellow is precious wetlands that we do not want to destroy. Mr. Mast asked the good question whether or not there was plenty of space in the RSF1 area. The answer is there's plenty of space. It's all in the wetlands, 100%. So we own this residentially zoned RSF lands in the northeast portion of the parcel, overlaid in deep yellow. Apart from that narrow veneer lining Albee Farm Road, it is 100% wetlands. I'm confident John O'Miller will be able to explain to you, if you want him to, how he thinks that may have happened and why it matters. But in the meantime, the balance of the parcel has been designated OUC. Even though that southern berm and spoils lands on the western portion of the parcel are high and dry, a remnant of the Cowpen Slough dredging filled with noxious invasive vegetation and originally intended for residential development as it was filled and graded in the early 1950s. When this parcel was created, there was no zoning ordinance in Sarasota County, let alone no minimum acreage that one needed for building a single-family home in OUC, or there were also no restricted on split zone parcels. We will be belaboring that point very soon. Before the year 1975, when zoning regulations were established, our parcel already existed in its current boundaries. In fact, the zoning administrator admits that the lot remained in its present form since the early 1960s. We actually bought it from the original creator of the subdivisions around it. John O'Miller's report showed that the uplands area to the west were already filled with dredge material from the construction of Cowpen Slough, and the property could be reached by car from Laurel Road. If you hang around long enough, you will be able to see wonderful aerials from that time. Constructing a residence at the location where we are planning to build would have been easily possible without any access issues to the site, at least up until 1975. What happened in 75? Sarasota County established the zoning ordinance and chose to designate an untouched salt marsh as RSF1 and suitable for residential development. And at the same time, they designated the upland spoil area as OUC. Oh, all that mangrove, just make it OUC. When I-75 was built in the early 90s, Sarasota County saw the need to drain the I-95 rainwater along Laurel Road all the way to Cowpen Slough and initiated an eminent domain takings procedure to establish a drainage easement with a subsequent dredging project, which led to the destruction of the formerly existing access path from Laurel Road to our building site. So you usually be able to access, and there was a turnaround here all the way till 1975. Throughout the decades of dramatic changes to this parcel, nothing affected the vested rights for the property owner of this parcel to build one single-family residence, regardless of those zoning designations. So before we purchased the land, it remained in the hands of that original developer of the surrounding subdivisions, did not change hands. Once the zoning ordinance was established in 1975, the RSF1 zoning designation was imposed on that salt marsh. I think I said that twice, sorry. In addition to Sarasota County Environmental Permitting Manager Howard Berna, 3 renowned environmentalist experts have investigated the property and found that the upland spoil area is infested with noxious, invasive vegetation, actually threatens the natural mangrove and other desirable native habitat. We consider this a zoning error. Unfortunately, Sarasota County administration has no mechanism by which a zoning error can just be corrected. I believe that's one reason we're here today. So, already back in 2016, we requested information regarding us as a non-conforming lot of record and how Section 8.4.1 might be applied to our parcel. As you can see there, we are not necessarily appealing these zoning code interpretation letters that I'm about to show you. There were several before we get to the one we're actually appealing. We've tried this for a while now. I'm sorry. So the response basically said, yeah, it would be a lot of record. That's pretty much what she said. That's a zoning code lot of record. She said nothing about a non-conforming lot of record, but that was nice enough. Okay, notice she did mention, though, that the site has historically been designated for residential use with RSF1 zoning. This is her first mentioning of that wonderful split zoning of our parcel and reminds us that no permanent structure shall be located on the part of zoned OUC, meaning we must build in the wetlands. We responded that Code 8.4.1 is supposed to protect the development rights of non-conforming lots of record subdivided before 1975. We received no response. Instead, we were suggested go for a rezone. That might work. So, we first were granted an Army Corps of Engineers permit. This included a federally approved on-site mitigation plan for unavoidable minor impacts. We're talking minor, like under 1,000 square feet, right around there. Okay. We also thought it might be intelligent to get prior approval from the state, erroneously believing that Sarasota County might consider science and facts on the ground more than loud lies by the direct neighbors. It took us 2 years to obtain our ERP from the Florida Department of Environmental Protection. It required considerable environmental scrutiny. I won't go into how much we had to do to get that ERP. We got it. County staff also affirmed before the Planning Commission that this approach provides a better environmental outcome than when it currently exists on the parcels today. Well, to say things did not go our way would be an understatement. The neighbors across the canal, armed with lies, misinformation, and alarmist rhetoric, made enough noise to make both the Planning Commission and the Board of County Commissioners not care about vested rights, not care about filling in wetlands on RSF1 land. In fact, they just said, well, denied. Didn't even give any real reasons. They just said denied. We couldn't believe it. So we filed a petition for writ of certiorari. And what did Judge Walker say? He denied the petition and explicitly based his ruling testimony, provided by neighbors across the canal, the Bucarts and the Martinis, stating, quote, granting petitioners relief would require this court to reweigh the evidence and substitute its judgment for the judgment of the board. Such action exceeds the discretion of and the authority of the court and is prohibited. The county persuasively argues that the board's decision to maintain the existing land use pattern is consistent with a comprehensive plan and serves a legitimate public purpose. I'm sorry, we do not believe that wetlands should be zoned as RSF1 zone property. We also don't believe that if on that same parcel there might be residentially slated uplands originally created for residential use. Should that be an OUC? Here you have been looking at John O. Miller's wonderful depiction of the quandary we're in. We are constantly told we must build in the wetlands, develop here, and cannot access, let alone use, or even put a driveway using our upland spoil area, which is trapped in miszoned OUC and untouchable with, quote, permanent structures because of its split-zoned nature. In November 2020, we submitted a second request for a determination letter via our attorney at the time. In her response, the zoning administrator wrote, I quote, I would reject the characterization that what is depicted in Attachment A does not qualify as a private infrastructure, serving limited area with no on-site personnel, minor utility, as what is documented as Attachment A is more than a culvert. So the only reason that I have this in here is to show you that double negative. I would reject that it does not qualify. And she never really officially recanted that wording. So we paid for a zoning code interpretation letter with a double negative that actually gave us rights. We also asked the methodology by which the Sarasota County Zoning Administration corrects an erroneously mapped zoning designation. The response was that there's no evidence that an error had occurred in mapping and zoning of our property, and that they only have the ability to correct Scrivener's errors. When the zoning administrator states, quote, I do not have the authority to interpret the comprehensive plan. In my humble opinion, the county is sidestepping the responsibility to properly zone parcels in line with not designation with RSF in 100% wetlands portion of a parcel. I would like to believe that you, the Board of Zoning Appeals, does have the authority to correct this blatant zoning error. Even though the county already had our zoning petition complete with a survey at this point, the zoning administrator said, without the benefit of a survey, it can't be determined if the parcel is non-conforming. Again, avoiding responding to the question, and she already had a survey at that point. Slide 14. So now we have arrived at the present zoning code interpretation letter that we are appealing. We start with the preamble. She insists that I would need to bring up equal protection violations at the quasi-judicial hearing and our petition for writ. Well, I'm bringing it up now. We hereby appeal her interpretation of 12475, which states roads and bicycles and pedestrians, similar trails and ancillary facilities are allowed in any zoning district. She's basically saying that all those she's construing, saying that bicycle trails and roads have to be somehow public. In our humble opinion, it doesn't state that, and therefore that should not be upheld. Now comes the non-conforming lot of record. She disqualifies our right to build anything, let alone a residence, on the upland section of our parcel due to the language ratified in 2004 in Section 12476A1F3, which we will from here on refer to as split-zoned parcel restriction. Where a lot or parcel is zoned in part as OUC and the balance is any residential district, no permanent structure shall be located on that part zoned OUC. This interpretation is incorrect in two ways. First, according to the zoning administrator, our non-conforming rights are allegedly extinguished by the split-zoned parcel restriction, forcing us to build in the wetlands area. However, I will be demonstrating that our non-conforming lots have building rights, notwithstanding limitations imposed by other provisions of the zoning code. However, even if we were not a non-conforming lot of record, this interpretation implies that the owner of a split-zoned parcel forfeits all rights to build any structures, including those delineated under 12476. Let's go to that section now. So, does it make sense to this board to prohibit all structures in OUC just because it has some residential land on the same parcel? The code's intent was to prohibit residential density and structures on the OUC land, not to strip prior structure rights granted, specifically the items enumerated by right in Section 124-76. Again, we'll be pointing out these numerous split residential OUC parcels with permanent structures in the OUC. Now we're going to turn to our rights as owners of a non-conforming lot of records. By the way, ours is 10 acres. Here you can see we have under 10 acres. Got it? Under 10 acres. She agrees. We're a non-conforming lot of record. Now, we can see from the development standards on this slide that we do not meet the size requirements for a single-family home. We all seem to agree that it's a non-conforming lot of record. Okay? So the zoning administrator relies wholly on that split zone parcel restriction to deny residential use in the OUC. So let's read the definition of a non-conforming lot of record, please. Oh, I don't know how to go backwards. I went one forwards. Let's not read what it means, non-conforming lot of record. Yeah. The important thing is the non-conforming lot of record has a provision in it which says if you already existed in 1960, you are allowed to build, notwithstanding limitations imposed by other provisions. I looked that up in Google. I don't use that expression every day and decided to Google it in quotes. So, notwithstanding limitations imposed, you will see that this is boilerplate contract law jargon, and it basically means despite of and regardless of, et cetera. It creates an exception to the rules, and I was excited to see that it's used nationwide primarily in cases of non-conforming lots of record. Here I cut and pasted a few ordinances from various places that use the exact same language. They all mean the same thing. If a lot fails to meet the requirements of area, width, or size, it is still allowed on a non-conforming lot of record created prior to the effective date. So the split zone parcel restriction does not apply to our parcel. So what were we allowed to do in 1960s? I'm going to go really quick. Wow, I found the Sarasota Zoning Code of 1963. I really worked hard to find that. So there it is, zoning, 18.2.8. Zoning. What are we allowed to do? Well, they're allowed to make a zoning code. That's what it says. They hadn't made it yet. So there were no restrictions, were there? Feel free to ask Attorney Pierce or Ms. Thompson whether or not that's the case. I also went the extra mile and researched all sorts of things about that. So we are now going to quickly go, and there's that 828 feet, and then she says, you know, you can't build in residentially zoned, so that's the part that we're appealing as well. I'm quickly going to go to, by the way, we do have also the qualified right to create a natural area park. I'm sorry, I've lost it here. So natural area park defined in section 124305. It's a permitted use in the OUC zone of split zone parcels. She concluded in her response that the WNCA aspect would be outside the scope of her authority. You know, sorry, somebody's got to take responsibility for whether or not we're allowed to do that. We paid $12.30 for this BZA appeal on top of that $500. So, you know, lacking an unambiguous zoning code interpretation, we can only conclude that they refused to process it, and our vested rights to establish a nature area park in the OUC zone was terminated from that split zone parcel restriction that shouldn't apply to a non-conforming lot of record created before that restriction. So this is quite an absurd experience. I'm going to come back to that concerned experience and just go straight into some of these other parcels that are all split zoned with structures in them, if that's all right with you. The first one, and this was amazing to me, you can see here that this is a split zone parcel. There is a very, very little bit up there in residential. See that? I see it. It's a little bit of a different color at the top of the arrow. But interestingly enough, the zoning code interpretation letter that Donna Thompson wrote for that particular applicant decided that it was 100% OUC, so he could go ahead and apply his non-conforming lot of record to a single-family residence entirely inside the OUC portion of his lot. He has two of them. As you can see, they're two sides of an arrow. Both of them are split zoned, but they were both called OUC by the zoning administrator, allowing them to build in the wetlands. I thought that was a very interesting one. Blackburn Point, split zoned structures in the OUC. 500 Tamiami Trail, split zoned. It has a permanent footbridge in OUC. 670 Alligator Drive, split zoned, has vehicular passage in OUC. Sea Fox Road, split zoned, one of my favorites since the bridge started in residential and crosses OUC with a 230-foot dock. It continues. There are so many, it's unbelievable. Thank you for your time.
have any questions for the speaker? I don't think anybody has any questions. Mr. Malatesta?
I might, I need like.
Oh, sorry, I'm just so cynical. Thank you for your questions. I appreciate. I wish I'd practiced more.
Okay, I guess I'll go.
Go ahead, Mr. Piacek.
There's a lot of stuff flying around here. If you could simplify it down for me and potentially the rest of the board, just maybe kind of explain
What I want?
what it is you're trying to do.
Okay. We have a
And
split. Yeah. Okay.
and what you're being stopped from doing.
Sure, I'll be happy to do that. We attempted to rezone. We were ready to give up all that area. Let's quickly go to that slide, if that's okay with you. I want to share the slide with you. Yes, of course, it's the second one, my dear. Let me go up. I think that's how you do it, right? And then we go click to get to the next one. So we offered, stop the swap. We offered a zoning swap. We said that we would give the entire wetlands portion in the northeast to conservation, and that we would only build an impervious road out to the land, which is high and dry, and it got all sorts of permits. But the neighbors were very loud, and that was denied. So we are saying we have a right to do that now. It's all our parcel, and it was subdivided before 1965. And she is imposing this split zone parcel restriction, saying no structures can be in the OUC if you have RSF lands. But in this case, my RSF lands are 100% wetlands. So if we get denied here, you know, we have some options. Obviously, we could always sell the parcel to a developer who will go ahead, and they have quite a bit of density potential in that RSF portion, right? In fact, I believe the zoning ordinance allows you to use the balance of the entire OUC to calculate how much residential you can put there. Therefore, all they need is a couple of 1,000 square feet of fill and a little mitigation somewhere else, and a big developer will shoehorn this one through. We didn't want to do that. We would like to build one humble house. And it has been our dream.
And
for many years.
My understanding is you can, but just not where you want to. Is that incorrect?
Right, we can build in the wetlands.
Okay.
%100 wetlands, sir.
Well, hold on 1 minute, Mr. Piacek.
So my question for you is, you've been through a rezone, it's been denied, went to court. Court said they backed the board's decision. What do you expect this board to do, given that we can't overturn or change either the commissioner's decision or the court's decision?
The beauty of tonight is that you don't need to deny their decisions. I believe that all you need to do is recognize our non-conforming lot of record has vested rights. What was it? Notwithstanding other provisions. And those other provisions are the split zoning provision created in 2004, Mr. Radziatsukis. So
Close, but not
sorry.
quite.
My eyes aren't so good.
I've been called worse.
I do not believe that the denial of the rezone petition only was for that narrow request for a rezone. We don't need to rezone. That's the beauty of tonight. You will not get a whole bunch of these cases. Let me tell you why. This is not precedential. You will not find another parcel like this in Sarasota County with those two designations. It was the strangest odyssey of our life. And quite frankly, all we would need to do is recognize our non-conforming lot of record, notwithstanding. So all you need to do is abide by your own provisions, sir. Thank you.
Mr. Malta?
You addressed my question. Thank you.
Thank you, Mr. Malatesta.
Mr. Piechek, do you have anything further for this speaker?
I don't think so. Thank you.
Thank you. Appreciate it.
Thank you, Mr. Arthur.
So the next speaker card that I have is for Akim Ginsberg-Klemmt. You're not going to speak? Okay. That's what I thought. So moving on, then I have a Jonathan Cole. And Mr. Cole, when you get up to state your name for the record, you'll have 5 minutes.
Okay, thank you. Yes, my name is Jonathan Cole. I'm with a firm, Giffords Webster Engineers, and just for disclosure, I was the one that designed the culvert to access this parcel. And I don't really want to talk about the rezone or the wetlands or the special exceptions. What I do want to focus on is an interpretation that came up during the application to simply build a driveway culvert to get to this parcel. Again, nothing to do with the rezoning or the single-family homes. The interpretation at that time was based upon a section of the code that described a structure. And in order to walk through this thing, I just need to, again, I need to kind of walk through those two sections of the code, which I don't know if you have them or not, but obviously they exist. So the fundamental issue, as far as I'm concerned, that will have a ripple effect not only for this job, but for all future projects that have similar zoned area, is the definition of a structure. So your code defines a structure as, quote, buildings as well as other things constructed or erected on the ground attached to something having a location on the ground or requiring construction or erection on the ground. This means virtually anything man-made, okay, including a survey monument, a rebar, a driveway culvert, which is what I was up here for to accessing, an informational kiosk in a park, in a nice wetland park, a street sign, a stormwater culvert, or technically even a mailbox. All those would be considered a structure under the strict definition of the zoning, okay, in your code. The problem is that interpretation of your code relative to OUC properties that also have a piece of residential land attached to it. Okay, so this is a split zone parcel, a little piece of residential, as you're well aware, as well as the bulk of it is that OUC. OUC properties alone, standing alone, have some limited rights. Your section 124-76B describes what those rights are, and they are basically four things. One, a single-family detached dwelling with limitations. Two, parks and open areas, and you have a lot of OUC lands out there that have parks on them with kiosks and driveways and things like that. Three, minor utilities, okay, sewer pipes, water pipes, manholes, FP&O lines. And four, barn and shade structures. You can have a little shade structure on OUC property. Okay, but at the end of that very same section, okay, there's a table that outlines the development standards. Under that table, there's a little tiny footnote, F3, that says, quote, where a lot or parcel is zoned in part as OUC and the balance is any residential district, this site, no permanent structure shall be located on that part zoned OUC. No permanent structure. Doesn't say no permanent residential structure. It wipes out all structures, and that's where the problem comes in. Okay? So note that the footnote did not state, and again, you have to kind of dig into the code to see these two areas. The footnote didn't say that, hey, if you have a residentially portion, then all those rights given just before here are hereby rescinded if the OUC property, in other words, the barn, the shade structure, the survey monument, all those go away if you have a little piece of residential. It didn't say that, although that's the way it's being interpreted. The next sentence in that same footnote reads, however, quote, in determining the total number of residential units permitted on a residentially portion of the lot of the parcel, the area of the entire tract, including the OUC parcel, may be utilized at the density of that permitted by the residential district. In other words, what they were saying is if you have a residential portion and an OUC portion, 10 acres, you can use the OUC density as long as everything that's built is in the residential portion. You can't build over in the OUC portion. So the whole point of that little footnote was that you couldn't build all your residential structures in the OUC portion. But it doesn't have the word residential, okay? So again, it was to limit how many residential go in the OUC portion. The staff interpreted that no structure, no permanent structure, because that's what it says, no permanent structure, not no permanent residential structure whatsoever can be built, which means no culverts. This is an OUC, and you have, like I say, acres of it out there. No culverts, no driveways, no survey monuments, no park kiosks, no informational signs, and all those structures that are clearly allowed by right in the prior section, just before this section. Utilities, barn, and shade structures. They're no longer allowed if you have one little piece in there. And so it's the interpretation of the no structures where really the problem is. If you just support the staff, that means all future pipe outfalls, all sewer lines, everything from the county, a mitered end section cannot be built in any kind of split zone because the interpretation is no structures whatsoever, rather than no residential structures. And in my mind, that has got a long-term implication for all OUC lands that have any portion of residential on it. It's the interpretation of structure.
Anybody have any questions for the speaker? Oh, Mr. Cole, thank you.
Thank you.
The next speaker card I have, is it Yulia Ginsberg-Klemmt? No? No, I have Antonio next. What is that?
Is that Erica again?
No. No. We'll get to that one. I apologize. I can't read that one right there. But we'll go to Antonio Ginsberg-Klemmt, speaker.
I'm just getting her slideshow up. Yeah, thank you. Okay. When you're ready, click there.
Chair, I have to object here. I'm not sure. They sent like all family members, which should have all been under part of the 20 minutes. If I'm understanding who the name.
She's announced maybe.
I understand it's an adult, but my point is 20 minutes is what's been provided to the appellants. I understand public comment, but we
Thank-
shouldn't be providing extra time
Mr.
to other individuals.
Thank you. Mr. Pierce?
Yeah, that's true. Is if somebody is up in support of the applicant as part of the applicant's case, ordinarily you count that within the 20 minutes. So, you have the discretion as the board to decide whether
3
or
minutes
not
is all I need. 3 minutes.
whether or not you want to allow for additional testimony from the applicant, and then the zoning administrator could, likewise ask for additional rebuttal time if they need it based on the fact that there has been additional testimony from the applicant. But it's entirely the purview of the board to decide what they want to do in this situation.
I guess I'd be fine with it.
Yes,
I'm okay with
The
it. yeah.
speaker's asking for 3
Yes.
minutes, and
Okay,
so
buddy.
we'll satisfy that. If you just state your name for the record, go for it.
Yes.
Thanks.
And my name is Antonia Ginsberg-Klemmt, and I've signed the speaker's card. I am a senior at the New College of Florida, earning my degree in environmental science and physics. Shortly after my parents bought the property, the neighbors from across the canal approached them on the parcel, said that unless my parents sold the land to them, they would make sure nothing was ever built there. When my parents refused to sell the property to them, these neighbors had one vengeful goal in mind: to turn the entire neighborhood against us and plant misinformation in the heads of the neighbors and the commissioners. Please listen to this recording from a neighborhood meeting my parents held with the neighbors for the rezone petition.
So that's fine. So my question is, right, for everyone here in the room, you want us to believe that this swap will protect the wetlands. Currently, the thing that everyone is concerned about, whether they're labeled wetlands by the state is the wetlands, whether they're appropriately labeled by the state or inappropriately labeled by the state, is the point where you want to build your house, which is the flow all the way through there, right?
This area here, right? Everybody can see? This is not wetlands.
I understand that.
Okay. This is.
Mr. Chair, point of order. I don't think this is relevant to even to the appeal. This is pursuant to their lawsuit
No, for the record.
and their rezone.
Okay.
This is important.
How much longer is this going to record?
To fill
We
in
get the point of that.
You've got like 10 seconds left.
use
All right.
the existing uplands. Is that correct?
Yes.
That's what the county allows you to do to protect the point. So I don't want to hear, save the wetlands, save the wetlands.
Yeah, so the main person who spoke in this video and who was who wants my parents to build in the wetlands is our neighbor, Mr. Gary Bookhart, who lives directly across the canal. Yes?
Mr. Chair,
Yeah.
point of order. They shouldn't be calling out people that aren't in the room or won't be able to defend themselves or anything like that. I think that's inappropriate.
Okay, understood. We understand your message. We appreciate that. So at this point, we're going to go ahead and yield your time.
Okay.
Thank you. The last speaker card that I have is for Joan O'Miller. Thank you.
I'll need the overhead. My name's John O'Miller. I came to Sarasota 51 years ago, started an environmental consulting firm with my wife in 1975, now retired. And I only take on projects that interest me. In August 4th of 2019, I was contacted by a couple who said they owned high land that had been dredged up specifically for development and that the county was forcing them to build in wetlands. It seemed hard for me to believe. I told them I would look into this on two conditions. One, that they couldn't pay me or compensate me in any way. And secondly, that I had to believe it would be, whatever they're proposing would be a net environmental improvement. Now, we all make mistakes, and unfortunately, the county has made two mistakes, and apparently there's no entity in the county that's capable of, standing on their 2 feet and saying, yeah, this is messed up, and we're going to straighten it out. So we know that the county made a mistake. This is from a letter in 2006 from the county zoning administrator at that time, and she wrote, the configuration of the property is important. You're proposing 2 dwelling units on the upland portion, and this is a version of the attachment, the illustration that was attached to it. And as you've seen in other presentations, this is the RSF1 property. It's all mangrove and tidal marsh. And these are habitats that, according to your comprehensive plan, are required to be preserved. They shall be preserved. So to tell people that they can go ahead and build a house there is directly contrary to the instructions and the explicit language of the comprehensive plan. The staff, in the staff report related to the rezoning, they had a finding that the RSF1 consists entirely of environmentally sensitive land, tidal marsh, and mangrove, not substantially wetlands, as you heard earlier testimony from Ms. Thompson. It's entirely wetland, according to your staff. Now, how did this come to pass? You probably know, if you've been around, you know that the historic approach to doing waterfront development in Florida was to dredge up a perimeter berm, a dike, and then pump spoil material inside it to create land. So you see these 4 developments along Shackett Creek. This one was built, this one was built, this one was built, and this one in yellow is the property we're talking about today. But that berm was built specifically to enable residential development. Now, this is what's called a LiDAR image. It doesn't show vegetation, it shows elevation. And so the blue areas, as you might imagine, are water. The green areas are wetland, and the reds and yellows are higher elevation. And you can see the spoil area is the same elevation as the subdivision to the south, and that it's pretty different than the rest of the OUC property. Now, this is a letter, a transcribed text from a letter, email from Donna Thompson, saying that the pre-1975 zoning maps show that the upland portion of the property was zoned R1, with lands now zoned OUC being mangrove. And she's correct. In 1975, that's how it was mapped. And if you see this illustration, you can see all of this is zoned mangrove. There's no recognition of any upland. There's no spoil showed here. And then on this half-section map, they've colored in this area in yellow, apparently suggesting that this is upland. And this is what the zoning administrator found in 2006. If we superimpose that LiDAR image on this image, you can see that, yes, in fact, it is wetland. The widening, the punching through of Albee Farm Road consumed a lot of this, so the parcel's no longer that size. So I got less than a minute. So there are two problems. One is the county staff, by not going out and actually looking at the property when they were rezoning, relied on an image, a map, and concluded that there was upland property where there wasn't. And secondly, by not going out and looking at the property, they concluded that a spoil mound that was constructed specifically for development that wasn't a native soil, had no native vegetation on it, that should be designated OUC. And if you look at the definition of OUC, you can see that's not really compatible. So as I said before, what's going on is that there were some injustices or mistakes were made. Let me pass these over to you, if I may. And this couple is simply looking for some venue where somebody could say, yeah, the county made a mistake, and here's a way to make it right. Thank you very much.
Just in case we have some questions for you, hold
Yes,
that there.
I'll hang out if there are any questions.
Mr. Mast? No.
You showed all of these?
I did.
Okay.
And they go to the clerk.
Mr. Chair, not really a question, but a statement. Thank you, Jono. You've done a lot of great work in our county on environmental services, and I appreciate your presentation. Thank you.
Thank you.
And Mr. Chairman, while we have a moment, just for some housekeeping matters, we've seen a lot of material that's been placed on the overhead, and we've seen, PowerPoint presentations. This is just a reminder, for a complete record, please make sure that everyone who made, a presentation today, make sure you get your items to the clerk so we can preserve those matters for the record. For the
Thank you.
proceedings.
That's why I passed them along.
Thank you. Appreciate it.
Well, thank you.
So at this time, maybe we'll ask Ms. Thompson if she has any rebuttal, or Ms. Kelly.
Just some general comments before Ms. Thompson comes up with a few specifics.
And did you want additional time first before we start the clock? In addition on
No.
the 5 minutes?
No, five minutes should be fine.
Thank you. Thank you, Mr. Pierce.
What you've heard a lot this evening, as we anticipated, is still contentions that the Ginsberg-Klemts have with the denial of the rezoning. That is not something you all can address today. That the Board of County Commissioners made their decision on the rezoning. The Circuit Court also looked at it and affirmed that denial. That is a done matter as far as the county is concerned, and certainly outside the jurisdiction of this board anyway. I did not hear anything today that contradicted the determinations that Ms. Thompson made in her zoning determination letter. I think she has a few additional comments to make in response to some of the items you heard. And also, would just point out that I forget which one of you mentioned it, but this is not a question about them not being able to build at all on this property. They have the right to build. It's a question of they want to build in a particular location, versus others. And that, again, ties back to the rezoning, which has gone through the process and was denied and is not before this board today. So with that, I'd ask Ms. Thompson to make her final comments.
Thank you.
I just have one additional point to point out, as they flashed up a letter stating that it was a letter written by me regarding a property that was allowed to be built in. As they went through their presentation, you can see that the letter was signed by Brad Bailey, who was my predecessor in the zoning department. So several of these properties that they have questioned have been allowed to be developed under a former zoning administrator who has interpreted the codes in effect differently than what I have. So I would like to point that out, that the one letter that they pointed out and said that I wrote stating that property could be developed was not signed by me. It was signed by Brad Bailey. Thank you.
Thank you.
Thank you, John. Ms. Thompson?
Yes, please, if you have a question.
Yeah, a couple questions. If, you know, it seems like this issue of something being labeled wetlands and not actually being wetlands, could you speak to that a little bit? Has that been sorted out, or was there, or is it in fact wetlands? The RSF portion is in fact wetlands, but it's buildable? Is that?
The RSF portion is wetlands.
It is,
That would
okay.
take some filling
Okay.
to build on it, which was why the rezone attempt was pursued to switch the zoning, which was ultimately denied.
And then there's this issue of the split zoning, and point in time you have it split, any kind of structures in OUC are then prohibited. Is there a little bit of background on that? Can you, I think it's been laid out to be kind of arbitrary and possibly nonsensical, but I have to assume there's a history behind that and some logic.
I can't tell you the history behind it, as that went into the code prior to my joining the zoning division, but it has been in the zoning code since 2003 that you could not build in the OUC portion if you had split zoning. That same statement about no permanent structures in OUC.
And it's just been moved forward
Yes.
to this day.
I would have to go back and
Okay.
research the older codes.
And I'm curious what implications this might have for the property right to the north, adjacent to the north.
If it has the same zoning, it would be the same way.
There seems to be a lot of similarities between some of the things that are going on with this property and the property just to the north. Thank you.
Thank you, Ms. Thompson.
Sorry, I have a question.
Oh, sorry, Mr. Mast.
Thank you for asking that question about the origination of the split zoning and the residential tied to OUC. The other question I have is, who does administer WNCA decisions? If it's not the zoning administrator, it's going to be WNCA, correct?
Yes.
And how would they go through that process to do that? That goes through,
I'm not
that's
sure.
a completely separate entity, I believe. Is that correct, Mr.
Correct.
Pierce?
Yes, there's a WNCA administrator, and the WNCA administrator processes, like minor work permits for certain things, and then they process major work permits for other items. And so ordinarily, when you have something that is not permitted as a minor work permit, that goes to the Board of County Commissioners under a major work permit. And the Board of County Commissioners decides whether that particular water-dependent structure, be it a dock, or if you're having dredge and fill operations, those would also be permitted through a major work permit by the WNCA, which is the Board of County Commissioners.
Thank you. At this time, we'll let the appellant come up and have the rebuttal, please.
Yeah, come on.
And both come up. Just state your names
that
for
would
the
be
record,
nice.
please. Yes.
My name is Ginsberg-Klemmt, and I wanted to state that we reached out, of course, to Howard Berner, who is the WNCA administrator, and asked him to process our WNCA permit. We have filed an application for a WNCA permit, but if you had watched or go into the details of the denial, the Board of County Commissioners was not allowed to process our WNCA permit without the prior rezoning. So it was at the same hearing, and the circuit court even struck the testimony about our WNCA permit, which says, that's not being processed. And Howard Berner only told us verbally that Nothing has changed, and he's not going to process our WNCA permit application until this rezoning matter is resolved. So you have the situation that the WNCA administrator says it's a zoning issue, and the zoning administrator says it's a WNCA issue. So it's a he said, she said. So.
I also wanted to answer one of your concerns about what the impact that this decision might have on the northern parcel. The northern parcel is a very different configuration. There is no spoil island accessible from the northern parcel. There is a small bit of uplands in the northeast portion of that parcel that is officially buildable. It's a completely different configuration. Of course, it's not at issue today, but if that was one of your concerns, the impact of your decision today as to whether or not allow the non-conforming use. I was surprised that nobody asked Ms. Donna Thompson why, she is still applying the 2004 restriction on split zone parcels on a parcel that was created, several decades before, and you do have a non-conforming lot of record ordinance in there that is supposed to allow for a single-family residence. Please keep that in mind. That is really important. This has to do with the vested rights of a non-conforming lot of record. That is the number one most important aspect of this meeting today. And my husband has something else to say. Thank you.
We also had to skip the topic a little bit about the natural area park. We are also basically apparently barred from establishing a natural area park on our OUC zone because of this strange wording in your zoning ordinance. A natural area park is a permitted use in the OUC zone, and we request that you please vote on this today, whether the natural area park is also a permitted use in the OUC zone of a split zone parcel. This is also one thing that we would like to work on. Erica can put our first slide up. That's where we ask you, where we have all the questions that we would like you to vote on today. It's 3 of them. Thank you.
And since I still have 2 minutes, I thought it would be nice, maybe you folks want to see some older photos that we had prepared for well, we didn't prepare it, but there they are. That is what you're looking at. There's that northern portion. Of course, it looks like it connects with Laurel Road. Back in those days, they did. And I think John O'Miller did show that to you, or something similar to it. We're going to go in a little bit further, and now in 1974, you can see that there was a road that came down. This is the area, and the only area that we were interested in having a small house. And like I said, we do have the Army Corps of Engineers permits, the DEP permits for a culvert, and right here, and the driveway with some small impacts that are taken care of with mitigation. And just to get a feel for all the homes around us, there they are, packed in. We would be more than happy to save the wetlands. Also to the north of us, we already spoke, earlier about the idea that, some kayakers were concerned, but then we can't go in here. Well, you know what, our home is down here. We're not planning on, stopping anybody from coming and being on the island. Yeah, this is also a drainage easement here, and you can see the surrounding zoning. So, and there's the 2 permits. By the way, here is the Florida DEP permit, so you can take a look at that while you deliberate. Thank you. I don't know if I can leave this up, but I might as well, because they can see a lot of stuff there. Thank you.
Does anybody have any further questions for the speaker at this time? No. Okay, thank you.
Thank you.
So at this time, I'm going to close the public hearing and open for the board to discuss. Mr. Piacek?
I think I would probably rather not deal with anything that doesn't specifically pertain to this property. I think we have a number of points that I think that are in contention. I think in the past, we've had kind of case studies submitted, I think, in support of applications. But to go ahead and kind of dispute or, I don't know, try to adjudicate these things, that's a little bit above and beyond as far as I'm concerned.
I have a question, if I may, Mr. Chair. It is for the county attorney, or even our the zoning administrator's attorney, and it has to do with what we're here today to take into account for. We've heard quite a bit of testimony, seen lots of examples, to Mr. Piachuk's point, but what are we supposed to be, and I know, but I just want to be reminded, what is it that we're supposed to be taking into account here? Example-wise, because we're here to either affirm or reject the zoning administrator's determination, correct? And that's truly what we're here to do.
Sure, and I can help clarify that. Basically, I think your focus is going to be on the request for a written interpretation, the zoning administrator's written interpretation itself, which is in the binder of materials. It's that letter dated August 11th, 2021, that provides, the zoning administrator's interpretation, okay? And then you're also going to be looking at, which is immediately before that, is the request for a BZA appeal. So the arguments that basically you're going to be looking at are in those three documents, I think are the crux of the issue. The request for a written interpretation, which is dated July 15, 2021, the written interpretation itself, and then the request for a BZA appeal. The information that you've received about, maybe there was a mistake in zoning and so on and so forth is really outside the scope of what you're here to do tonight. Okay, you're not here to correct, any alleged, inconsistencies in zoning. This was one of the subjects that was part of the rezoning and the certiorari proceeding as to whether there was a mistake in zoning or not. So that's kind of beyond your ken, if you will. You are guided by, the language of the UDC that basically directs you to look and determine whether or not the zoning administrator's decision, in this case, 27 of them, are correct or incorrect. And so you can affirm, you can reverse, or you can modify any of those 27 different interpretations. And you can take them as a group, you can take them as subsets, you can take them individually. So you can decide how you want to do that. But basically, the scope of what you're looking at is in those three documents, the crux of it. The other information does provide you with background information, but really your focus is on those 27 different items and whether the zoning administrator was correct or incorrect.
Do you have a recommendation to take them one at a time, or?
You can take them one at a time. If you want, you can take them in groups. We've heard a suggestion from Mr. Piachuk that the ones that do the comparisons with other parcels, which are items 9 through 27, you can decide those as a group and decide we're not going to try to do comparison contrast with other parcels, and then focus in on the items. It would be items 2, 3, 6, 7, and 8, and then take those individually if you want. It's up to you to decide, which direction you want to go. It may be easiest to look at items 9 through 27 as a group and decide, do we want to entertain those and look at those, comparisons or not. You've heard testimony from both sides tonight. One is that they would like you to make those comparisons from the appellant today, and two, you've heard testimony from Ms. Thompson and arguments from her attorney that that's beyond the scope of what you're doing here tonight. And so you can be guided by the language that is in those letters, the request for interpretation, the interpretation letter itself, and then the appeal, those three documents, to help guide you in your decision in making your decision tonight. So it may help you to look at those arguments. If you want to look at 9 through 27 first, weigh those arguments and then decide, do we want to get into those or not? Or save those to the end? It's your discretion as to how you want to proceed.
Thank you.
Mr. Chair, I would like to take 9 through 27 as a group to start with. So I would make a motion to do that.
I would second the motion as well.
Secretary, could we take a roll call on that?
Wait. What is the? You're just to consider them separately?
As a group them as one, yes.
Consider them as a group rather than individually.
Okay. Okay. Okay, I understand.
Are you on? Thank you.
Yeah, sorry. So 9 through 27 is the comparisons. Assuming we can attack this, I would be inclined to just vote to uphold the zoning administrator's recommendation on 9 through 27. I don't, do we have to vote on just separating it out? I don't think procedurally.
You don't necessarily need to do that if there's a general consensus among the board members, unless if somebody says, no, I want to hear those individually, then maybe you need to vote on it. But if there's a general consensus among the board members, we want to just, make a motion as to 9 through 27, whether to uphold or reverse or modify, you can do that.
Mr. Rudowski can amend his motion, maybe?
Well, I think at this point, then what we'll do is we have a motion, we have a second to group 9 through 27. Mr. Pierce is suggesting if there's no objections to that from any board members, then we don't need to have a formal vote to group 9 through 27. Does anybody have any objection to group the comparisons, items 9 through 27?
No.
Okay, so then we'll collectively approach group as a comparison 9 through 27, then items 1, 2, 3, I guess 5, 6, 7, that leaves us 1 through 8. Now, 2, 3, 6, 7, and 8 could be grouped.
Or you can consider those individually. It's up to you.
Is there any sentiment on the board as to what their position is with 1 through 8?
I think let's figure out what we're going to do with the other ones first.
Okay, fair enough.
It sounded like Mr. Malatesta may have had a motion or working on one there. Did you want to?
Yeah, if no one had any additional discussion, I would move to uphold the zoning administrator's interpretation specifically on 9 through 27 of the,
I would second that motion as well.
So then at this time, Secretary, if we could take roll call on that. You're welcome. Yes.
For the motion.
For the motion.
For the motion?
For the motion?
For the motion.
for the motion.
For the motion. Thank you. So moving on.
Now, Mr. Chair, remember that not all items 1 through 8 were actually appealed. They only appealed certain numbers. So they appealed 2, 3, 6, 7, and 8.
Correct. Got it. Yep, that's what I have.
So you can take them as a group. You can take them one by one. If you want to have discussions one by one on each of them, you can certainly do that.
Does anybody have a discussion on any of the items 2, 3, 6, 7, or 8? Mr. Mass, is that raising hand? No, sorry.
Mr. Chair, I would I'd be fine to go through those one at a time as a board, unless any of my other board members have any other recommendations.
I think that's fair.
Fair. So be it. So then, that being said, is there any discussion on item 2?
I believe the zoning administrator adequately answered that, and I would make a motion to support the zoning administrator regarding number 2, request number 2.
Are you making a motion for
Yes,
that? Okay,
yes,
sorry.
I'd like to make a motion.
Okay,
for
thank
that.
you. Do I have a second?
Second.
Okay. Ms. Ledoux, if we take a roll call for item number 2, please.
For the motion.
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 For the motion. Okay, so moving to item 3, appeal request 3.
Mr. Chair,
Mr. Mast.
as we heard from our county administrator and our county attorney representative, Mr. Pierce, and our zoning administrator, I move that we uphold the zoning determination request number 3.
We have a second for appeal request number 3.
I'll second that.
For the motion.
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 For the motion. Moving to item 6, appeal request 6. Any discussion? Anybody have a motion on the table?
Mr. Chairman.
Yes,
for
Mr.
Number
Mayor.
6, since it is, also has to do with a WNCA permit
Right.
outside of the scope of the zoning administrator, I move to uphold zoning administrator's determination.
I'll second that motion.
Did you get the second, Ms. Ledoux? Okay, thank you.
For the motion.
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 For the motion. Okay, moving on to appeal request number 7. Any discussion?
Mr. Chairman, I'm not making a motion, but the discussion, I actually feel for Ginsberg-Klemmt's. As you know, I've stated many times, I'm for developing land and finding any opportunity to make it work. Having that the code was created in 2003, and I think there were some very valiant decisions by other zoning administrators to go against the code, clearly go against the code to provide access and construction in an OUC. I don't see how that is pertinent for our current zoning administrator to make that determination. And it's unfortunate that we can't overturn a county commission on a rezone, because I would have voted for the rezone. However, sitting here, it's not our purpose tonight to overturn that rezone, and there's really no reason to overturn the zoning administrator's correct interpretation, in my view, of the parcel as it's being spoken. But I reluctantly am not going to make the motion.
Mr. Malatesta?
Just to echo kind of similar comments, the legal framework that's designed to protect wetlands, ironically enough, is the exact reason why we can't really do anything today, because we are within the confines of what we see before us. So I also feel for the petitioner, but there is nothing, I believe, that we can do specifically sitting here today.
Well, I agree with what's being said, and I feel for the petitioners too, because they actually had a very good environmental plan. And I guess I'll make the motion then to uphold the zoning administrator.
There was a motion on the floor. Do I have a second?
Can we just specifically, what one are we on? Just so
We're
for
on
my-
appeal request number 7.
Okay, thank you.
We'll have one more remaining after this. Just wanted to make sure. Yes, sir. Again, second for the motion that's on the floor. I will make the second.
For the motion.
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 So that leaves us on our final appeal request number 8. Any discussion on the floor? So I think at this time, I would mirror the sentiments that have been shared here for the appellant. Certainly can understand the perceived steps of errors that have possibly taken place through this, going back to the 60s, as you had some references. Just understanding that the process for us this evening to uphold interpretation has nothing to do with other than just that. And the interpretation as the code currently is nonconforming, and the split zoning, the interpretation from the current code, from my lens, is to be upheld. And I do share and wish and hope that there's a way around getting to where it is that you want with this property, but I am going to make a motion to uphold the appeal request number 9 and interpretation. 8, excuse me, thank you. 8 for the ZA's response to the question, evasive and discriminatory. So I would make a motion to uphold.
Second.
Having a second, can we take roll, please?
For the motion.
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 For the motion. So moving on, the next item is to approve the minutes of, looks like the September 20th of 2021 meeting.
So moved.
Mr. Malatesta. All in favor, say aye.
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 There it is, okay. Other business, is there any other business? I guess for the record, I would just like to thank Mr. Malatesta for last September's filling in. I had a, wow.
I tried to get it out in 13, but it didn't work.
You're a natural. I felt like you were the chair.
He's
Mr.
about
Ch-
ready to be.
Mr. Chair, I do have a brief question for the zoning administrator.
Yes.
This question I have is just relating to the information that we receive. The binder that I got in the mail, was that all created by
The applicant.
Mr. Miller? Okay, by the applicant.
Yeah.
I had a hard time differentiating between what the packet was as presented from the county as to what was sent in by the applicant, because I was looking for letters that I assumed that I should have received from the county, but they were in the binder. So I just wanted to know going forward to make sure that we can say, this is the packet, this is extra material sent in by the applicant.
So in this instance, everything that the county provided you was on the outside of the binder? So it was the cover memo, the presentation, and the letter of interpretation that they appealed? And everything inside the binder was submitted by the applicant as documentation for their appeal?
Okay, because I did find some of the documentation to be helpful, and I did need it, including some emails and some letters. So I guess if that's not standard, then just, I guess, forget my comment, but.
Well, and that's kind of what I was saying earlier on, that it seemed like the staff's presentation was a little bit slimmed down and summarized, and that we were actually relying on the applicant's submittal a little bit to kind of get some of the background documents. And for the sake of saving trees, I guess I don't really have that much of an issue with it, but
I provided the background that was pertinent to the appeal of the interpretation. that I
slimmed
made.
down and summarized, yes, or to the point, and yes.
Correct.
Okay.
Thank you.
So so it looks like the next item, Ms. Thompson, do you have something other under business?
No.
Okay, so the next item on the agenda is the election of officers. Anybody?
Mr. Chairman, ask a question.
Chair, question, sure, yeah.
Yes. Is there a typical way that the elections are held on this board based off seniority, or is it just
No.
whoever gets nominated first?
No, I think in the years that I've sat on the board, what we've done is generally the vice chair would slide into chair, and then we would have an appointment on the board for a vice chair. And then that way, that kind of cycles through, if that makes sense.
I think Piaczek wants to be vice chair. He's waving his hand.
You did wave his
You
hand.
can hear that from down there.
I have a question. Technically speaking, I'm up for renewal, and this is, unless the BCC decides I'm no longer wanted.
I've heard iffy news, yeah.
So I guess.
Well, that makes two of us, because I just received my letter today before I drove here.
Got mine. Yeah, I got mine too. I did the application this morning really quickly.
Oh, did you? Okay,
well,
so
then-
it looks like a lot of our heads are on
I
the
guess
chopping block.
it'll be an asterisk.
I would be happy to nominate Mr. Malatesta for chair and Mr. Piachuk for vice chair. Can we take those together, or do they need to be separate?
Unless there are additional nominations that somebody wants to
I second that nomination.
Yeah.
Thank you.
No contested race?
Aren't those the best races?
Yeah.
Anyone going to nominate themselves?
Is that a motion, so I can second that motion?
We had a second.
We have a second.
We already had a
Oh.
second, yeah. But you want to put a third on there? You feeling left out,
He
Mr.
loves it that
Mance?
much.
Vice chair.
Vice.
They're on both
Mr.
sides of me.
Mr. Malatesta, the current vice chair would be chair. Mr. Piachek would be vice chair.
Yeah, I did.
Mr. Powell.
I did.
Mr. Powell did.
The two justices made the nomination.
J squared.
Yeah.
We were going to have a J square run.
That's our next election, J squared, yeah. Come.
Voice, so we just say all in favor, say aye. All in favor, aye.
Aye.
No objections.
Thank you.
And meeting schedule, looks like, is there or is there not? Confirm me.
There is a meeting in December.
Okay, December 13th.
It will be another appeal.
Oh, Merry Christmas.
Is it, Mr. Chair, is this your final meeting as chair, or is that the following meeting?
If as long as I'm breathing on December 13th, I think I hand over now.
Okay, well, then I would just like to say, and I'll speak for myself, but I think you've done a fantastic job as chair. You've led by example, and there's always different points of view coming into this board, and I think that you were always able to cut through and able to manage a meeting. So thank you for a great job, great year as chair.
Here. Justin, can you give some examples of that? I mean,
We'll play it back on Access Sarasota.
it's very detailed,
Just
so
go
I was
watch
just
them
curious.
all.
Some
Yeah.
some really thoughts I got out.
Thank you, Justin.
Well, thank you. I guess if there's nothing else, we'll adjourn the meeting of the November 8, 2021 agenda, Sarasota County Board of Zoning Appeals.